Good afternoon, everybody. My name is Steve Slocum. I'm the director of Aero Innovate, and we are now on a webinar entitled Protecting Intellectual Property, Research-Based Decision-Making. Hope you're all in the right spot. We had a couple of technical difficulties at the beginning, but we're, I think, working through those, so hopefully everyone will be good to go. If you have a question for us, please, we have everyone on mute, so please feel free to type that into the messaging on your screen, on the little dialog box for the GoToWebinar, and I'll get that and I can address things on the fly. So without further ado, we have a action-packed next hour for you, and I want to kind of get going and get right into the meat of this. So here's our flight plan for the day. We're going to talk a little bit about our presenters. We're going to give a brief definition of what Aero Innovate and Accelerator is, and then we'll get right into our guest speaker, Ellen Krabbe, and she's going to be talking about protecting intellectual property and research-based decision-making. Then at the end, we will have a Q&A session, and again, if you could submit any questions that you may have via the text box, the message box on your GoToWebinar menu, that would be fantastic. So today we will have Ellen Krabbe. She's the founder of FRESCO Services. I'm happy to say that she's based here in Wisconsin. She has also been based in France. She's been around the world and has outstanding experience in intellectual property and, most importantly, researching what is intellectual property and what is defendable. And I'll let Ellen talk a little bit about that in a minute. And again, my name is Steve Slocum. I'm the director of Aero Innovate. We're based in Oshkosh, Wisconsin. We are founded here at the University of Wisconsin-Oshkosh, in 2007. And our goal is to help aero innovators from around the world start and grow their aero-related businesses. And I think we kind of coined this term, aero innovators and aero-related. Basically, even though we are located here in Wisconsin, our companies that go through our accelerator can be based anywhere in the world. We facilitate the alignment of passionate investors and industry leaders with the best aviation-related opportunities in the world. That's those aero innovators that have an idea, and we can help them pair with mentors and get their idea off the ground. And we have a partnership with the Experimental Aircraft Association, which is based here in Oshkosh. We have Boeing Horizon X and University of Wisconsin-Oshkosh are our main partners. So real quickly about Aero Innovate, here's some kind of key timeline dates for us for this year. Our application for our 2018 cohort, the deadline for that is Friday, March 16th. We have a 5-company cohort every year, and we started our accelerator back in 2015. The pitch portion of Aero Innovate has actually been around since 2009. So this year will be actually the 10th pitch and mingle event that we'll had. We will interview every company that applies for our accelerator, and our final decisions will be made by Friday, May 4th. Our 8-week accelerator begins on Friday, June 1st, and that is a virtual accelerator, so you can be based anywhere in the world, but we do ask that you come on site here in Oshkosh for the final week, for the 8th week of the accelerator. And that is because it is during EAA Air Venture, where there's 590,000 people here in Oshkosh for the air show. And we also have our pitch camp on Friday, July 20th, Saturday the 21st, and Sunday the 22nd, where our companies come into town, they meet their mentors, they meet our staff, and we go through a camp that helps our companies get ready to pitch in person on Wednesday the 25th. It's kind of a who's who of aviation and aerospace that's in Oshkosh for that week, and it's a fantastic turnout at our Pitch and Mingle event. Some of our digital information, aero-innovate.org, and that is also where you can apply for our accelerator, and that is where this webinar will be stored. So if you miss any of the information, Ellen has some fantastic information coming up. If you missed that, please feel free to go to aero-innovate.org. We should have that posted probably by tomorrow, for sure by the end of this week. Facebook is /AeroInnovate. We're on Twitter and Instagram as well. So I invite you to to follow us digitally. So without further ado, I'm going to switch it over to Ellen Krabbe. Ellen is the founder of FRESCO Services. Ellen, I'm going to change presenters here. So hopefully our technology will work.
Okay.
Do you have the ability to change that?
Yeah, I just selected it. Hopefully we're popping up on that. You should be seeing it's the same slide, but we should be onto my slide deck. So I just want to welcome everyone, and thanks for being here. As Steve has said, I've worked actually for the last 7 years now in intellectual property. Before that, I worked in Europe as a technical translator and trainer, and I have a lot of background in engineering and a lot of other very sophisticated technologies. And what we're going to talk about today is the role of intellectual property and the need for research-based decision-making in protecting new ideas, new products, and new businesses. So we're going to look at an overview of the R&D process and where IP protection comes into that process, the different forms of IP protection, and some of the advantages and benefits that protecting your innovation can bring. Okay.
Can you change it?
So I got it.
There you go.
Examples of IP and aero innovation. I just wanted to give you some idea. If I put into Google Patents aviation, there are over 200,000 patent documents that are present since the 1960s. You see a great peak. On the right-hand side, the graphic shows there's a big peak beginning in the 1960s. That includes all industries, including aviation, aerospace, etc. And that began with the Wright brothers. It would be a key patent, first patent dating back to 1906 for a flying machine. And the most recent published document was a Chinese patent application for an automatic pilot system of unmanned helicopter. So you can see we've come a very long way over these years, and the innovation has been very rapid. If you look at where the Wright brothers were, and then quickly thereafter, I mean, people, the mail was being delivered, fighter pilots were being trained, and now where we are in space exploration. So there's a lot in this area. But there are also, in addition to patent documents, there are also many trade names, many products, many trademarks, and also there are trade secrets. And so we're going to look at all those different forms of protection that are used for promoting and protecting innovation. What I want to do is look at a pyramid of the innovation process. And I want to give you this bottom line question: can you make money with this product? It is kind of the bottom line, because if you're not looking to develop a new product and sell that new product, or develop a business based on a new product, then you might be just in the category of a hobby, which is okay too. There's huge innovation that has occurred from people just spending time thinking about new things. But we're going to get into this from the standpoint of, how do I build a new product in a business? And here's our foundation. We're going to start out with technical research. And a lot of what I do is in this area of technical research, intellectual property research, and competitor research. These three areas are specific to patent research. By doing research on patent documents, you can get technical information, you can get legal information, and you can find out what your competitor's doing and where the cutting edge of innovation exists. And this research will answer these fundamental questions. Can it be made technically? From an IP standpoint, is there patents that would prevent me from selling or making my product? Can it be sold? Can it be branded? Can I perhaps get patent protection? That you can find out through this research. And the last one is, as you go through the research, you see what competitors are doing and have done, and you can identify, how is this product distinctive? And so a lot of what I do is in that area of patent research. which answers those questions. But when we add to those market research, you get answers to the questions such as, is there a need? Is it sellable? And at what price? You need that information to determine, can this actually be a product that I could develop a business and a new product with? And the last one is consumer research. Will people actually want to buy it? Can I get my innovation in front of major players, and would they buy it? This is the foundation, and that the reason that research is so important is when you've answered all these questions and you've said to yourself, yes, I think this can be a product that can move ahead, then you go to the next level. So the next level includes things like prototyping and development. That, of course, can be developed initially, and sometimes it is even before doing intellectual property research, but it's important to get these questions answered before moving on too far. And it's essential that the legal work be accomplished very, very early. In fact, deciding whether it can be patented, whether I'm going to keep it a trade secret, needs to be decided sometimes even before doing extensive market research and consumer research. And the main reason for this, and this is very important to know, is if you go and show it to a lot of people or discuss it and disclose it, what we call disclosure, you cannot patent it later. So there are situations in talking about and presenting your product, if you pitch it in front of other people before you look for protection, you will not be able to go back. You may not be able to do protection.
So, Ellen, would your advice then to entrepreneurs be, before you talk freely about your ideas and before you pitch to any potential investors, to make sure you are protected?
Yes. It is important to already have in mind your strategy concerning possible intellectual property protection. And I'll go through some examples. There are ways of going about market research and consumer research that you could do, but I think what's important is to think about intellectual property very early and know how you're going to manage every phase of this development process. Yep.
Great.
After legal work, and it's not after, it could be before, but this second level is really important, is to think about, and here we're still in the relatively research inexpensive phase. You'd want to develop a business model because you have to answer the questions, where are my resources going to come from, and how am I going to make a profit? So it's important. This is theoretical. It's the best guess of how your business will look, and that's also the case with your business plan, because as you begin to look at this and calculate out, how do I need to raise capital? How is this going to go about? Who are the major players? So all of that comes together, and here we're still at a very theoretical level of developing the product or a business. Again, at this level, there comes a point where you need to stop and look at all the answers to these questions and say, does this look like I can develop this further with a potential for getting a return on my investment? Because beyond this point, there are real serious investments that may be involved, and you want to know that you've established good research to make that decision. Yes, I can get a good return on my investment. So from there, it goes up into what we would consider more of the development phase. R&D is for everybody, including entrepreneurs, and so this development would be the industrial scale-up. A lot of times it's continued technical development. New improvements on the product may occur, and in which case they need to be reevaluated. You would be beginning to look at a serious market plan because you want to launch, or you want to decide how you're going to pitch your product. And then you would head into manufacturing, sales launch, which you control, and that's where you would end up with a successful product. But it's really a foundation of research and good business decision making in those first two levels that allow for a strong progression through the rest of the process. Because I will give you an example. I've met people as I've gone along that hadn't followed this process, and sometimes they had jumped up into thinking about manufacturing. And in fact, I met someone that didn't have the technical issues worked out before going through and starting to invest important sums of money. And unfortunately, technically, it couldn't be made that way. So in fact, the person has to go back and almost start at the beginning, re-looking at the numbers. How can I make money with this? What's it going to cost? So it becomes very inefficient. If we go through a logical process, it's more efficient, cost effective. And so that's a real benefit to going through this process. So I will continue on, certainly add any questions to the chat section as we go along, and we'll try and answer those as we go along.
Ellen, if I may, just to kind of add to that pyramid, I think as I was watching you go through it, it's very, very similar to some of the criteria that we use in selecting a company that will go through our accelerator. So we have many companies that apply, and we have a fairly lengthy review process, and we have to look at a lot of these things, especially on the base of your model, and it really comes down to, can you make money from this product, and kind of what is your secret sauce, and that makes it different from competitors and makes it defendable and will make investors want to invest in your company to help you move along to these higher levels, and B, ultimately, will anybody buy it? And so I think it really plays in very well with many of the decisions we look at in selecting our cohort for an accelerator, and I'm sure other accelerators look at very, very similar things. So yeah, it meshes perfectly. I love the pyramid. I might steal that.
Okay, that's okay too. It is, this went through a lot of reflection, a lot of review of what is a normal process for an entrepreneur, and when we apply good practices, everyone's going to benefit. There'll be efficiencies and cost-effective innovation going on. So let's move on to the different forms of intellectual property, and the first form is confidential information. Your idea, the first concepts that you have are confidential and need to be taken into consideration. But confidential information is defined as information that has commercial value. It's not already in the public domain. It is reasonably protected, and it's communicated to others in confidence. And just to give you some examples of those, I see it's locking up a little bit. There we go. Your ideas and inventions, data, customer lists, business processes, business financial information, that's all confidential. So every business is concerned by this form of intellectual property, which is confidential information. And this, if you are not sure realistically if it's information that you would not want other people to see posted on a website, then you would just consider it confidential. There are general advantages to that, and specifically a form of confidential information we deal with is trade secrets. Trade secrets are protected by law, but they must be kept secret. And so this means that if you have information that you want to share with someone, but you don't want that information to become publicly known, you need to share it using a non-disclosure agreement or a confidential disclosure agreement. Trade secrets can be much more valuable than patents because they last as long as you can keep it a secret. I'll give you a couple of examples, such as the formula for Coca-Cola or the recipe for spices for Kentucky Fried Chicken. There are many, many companies that have built their entire business on trade secrets. And by keeping them secret, they last longer than a patent does, and it becomes very valuable with time. There are, however, proper ways that you can learn potentially trade secrets without violating the trade secret protection. Reverse engineering, for example, is possible. If it can be reverse engineered, then you properly can't keep it a secret. And that's why a lot of times we consider doing patent protection, and primarily what patents are a form of protection that allows someone to get protection despite the fact that that somebody normally could reverse engineer or understand their innovation. So it's a form of protection for that. But if it can't be reverse engineered, if it's not detectable in the final product, and if it can't be reverse engineered, if you say that it can be, if you say yes, then you probably would want to consider patent protection. And for many mechanical products, it's typically patent protection, because someone who works in mechanical engineering could look at it and figure out how it works. So that's why we deal with that. But many times the areas of industry that are typically concerned with trade secret are compositions that are undetectable in the final product. A lot of adhesives, once you put the ingredients together, you can't disassociate them. They have synergistic effects, and those can be kept secret. So it just depends on what part of the industry you're in. The next thing I wanted to touch on, because everyone who develops a new product or new business is concerned with names and branding. And the first place that starts typically is in domain names and social media. There's a link on GoDaddy, at least there was. I got this link. You can find it at various other places. If you did a Google search for tips on domain names, typically you want them to represent your product or your organization. You want them to be easy to remember. You would want to choose the appropriate extensions, a .com or a .org if it's a nonprofit. There are many other extensions that are used today, but most typically we see .coms or .org for a nonprofit organization. But really, I encourage people, it's not expensive to get a domain name, but you want to work on your branding from the beginning, and that includes domain names, social media names, and trademarks, thinking about trademarks. So these are forms of property that are important for anyone. This, if you don't remember anything else, this site, namecheck.com, is a site where you can sit down and think about, what do I want to use for a name? And it will tell you whether you can get the domain name, the trademark, and all of the social media name under some configuration. And that's really the ideal. Could you get all of them so that you have a consistent and coherent brand identification for your new product or your potential business? Social media names are free and domain names are not expensive. They would be expensive if you had to buy them later. So I encourage you to do that early. Along with branding, of course, are trademarks. And trademarks are something that kind of are less intuitive, in the sense that for domain names, we say take a domain name that describes the product or is what it is. But on the other hand, trademarks have an inverse correlation between strength and ease of understanding. If we start on the right with generic or aspirin, that's not possible to get a trademark on. Those generic words are not possible to be trademarked, and so they're not possible. So you don't want to use a name that is something that's typically just a word. Descriptive, it's possible but difficult, and you notice it's difficult to trademark a descriptive word or phrase, but it's easy to understand. If you say it's not brand cereal, well, yeah, that's very descriptive, easy to understand, might make a good domain name, but it might not make a good trademark, and you might not be able to trademark it because generic words are not easy to trademark. Then we get into the suggestive, like chicken of the sea. That's not totally descriptive. It's suggestive. It's easier to trademark, but of course you've got to build energy into establishing a brand. And so if we move on to Starbucks is arbitrary. Another example of an arbitrary trademark is Apple. Apple is a word, but it's applied to something that's not related to it, like a computer. And so arbitrary use of words for a product are strong trademarks, and they're easy to get a trademark for, but they're actually not intuitive. So you have to put, again, more energy. And the last one is fanciful, made up words. And you can make up a word, and those are the easiest to trademark, but they may require energy and time to make that brand recognized. But once it is recognized, no one will use it and people will understand. The purpose of trademarks is to identify the source of the product. And once you've identified a product with its logo or source, it makes it so much easier then you have a very strong brand and a very valuable form of protection of your products. So that's it for trademarks. And there is a link, and if you get to download this presentation, a link to the USPTO basic trademarks. There's very, very good information at the United States Patent and Trademark Office in helping you to better understand what makes a good trademark and how to get one. So one of the last forms of protection, and some people probably, if you were into applied computer code, apps, or related technology along with aviation industry, you might be more concerned with copyright. Copyright it's a form of protection that's provided to any author of any original work of authorship fixed on a tangible medium of expression. So you're probably familiar with your literary works are copyright, computer code is copyright, dramatic works, plays, musicals, music, and artistic works, audiovisual, and even architectural features can be copyright. There are entire industries. The film industry and the music industry are primarily use this form of intellectual property, and it's very lucrative. If you were in the area of doing audiovisual, photo, anything, certain computer apps or programs, video, you would want to get a very good copyright attorney to work with the royalties that go along with that type of protection. What you need to remember is the answer to this question: do I need to have a copyright notice on my work? And you'll notice copyright notices on websites, documents, etc. In fact, since 1989, a notice is not required, but it is recommended to avoid the innocent infringer. People cannot today say, oh, I didn't know, and so therefore I took, half of his book and then I used it in my book, or I took 3 minutes of his music and put it into my video. Today, people can't use that as an excuse, but it is still recommended to use a copyright notice. It just makes it very clear that assuming that these are your rights. So it should always be placed on your work in an obvious spot. And like I said, websites, documentation, any form of documentation that you want to be sure that people understand that you're the source of it and you maintain rights for it, you would want to put this on. And it looks like this. It's copyright with the circle C, with the date, then your name or your company name, and all rights reserved. That's the simplest form of a copyright notice. But remember, it is already copyright when you put original thoughts down on paper or original drawings down on paper or any other medium or on a computer program. They're actually yours. And other people can't legally use them unless you allow them to. So we'll move on to patents, and a lot of innovation is really concerned by this form of intellectual property. As I already mentioned, any new product or new business is concerned with confidentiality, secrets, mentions of branding, trademark, social media, domain names, etc. And then those that can meet the requirements, patent protection is the strongest form of protection that you could obtain for your new product. The origin of patents is actually the possibility of getting a patent was written into our Constitution and developed very early. And the goal of patents was to promote innovation. So we're in the heart of it here. Innovation, and in order to promote innovation, the goal of having patents was to give protection and a limited monopoly for that product for a limited period of time. Today is 20 years. in exchange for disclosing information about that technology, how it's made, how it's used, and what's key to the technology that's covered in the patent claims. And that's why I said doing patent research is a great way to speed up your innovation process by benefiting from what others have done. If you're working in a certain area of innovation, whether it's mechanical or chemical or electronic, you can see what everyone has done before you, and you can benefit from what they learned, what worked and what didn't work. So patents are an extremely useful source of information and technical information. They do, in order to get a patent, they must meet 3 major requirements. One is useful, and that almost all new ideas or innovations do meet that requirement. They need to be novel, which means they never have been seen before and they have not been disclosed. We talked previously about disclosing, and that's where the novelty issue comes in, and why it's important to get a strategy for how you're going to protect your innovation early before you do a lot of discussion with people outside of those who are working directly with you. And the third requirement, in the United States, it's non-obviousness. And in Europe and the rest of the world, they call it, does it have an inventive step? And what this means, an obvious improvement would be just to make a material thicker. And as a result of making it thicker, it becomes stiffer or more robust or stronger. Well, that's kind of an obvious improvement, because we know that if you make something thicker, it becomes stiffer and more robust. So it has to be more than just an obvious change. So there are the 3 requirements: useful, novel, and non-obvious. And then there are only certain things that can be patented. One is a process. One is number 2 is a machine. 3 is an article of manufacture, which you can replace that with the word product for that explanation. And the 4th is a composition of matter. And typically compositions of matter would be fuel compositions. Like I said, adhesives are compositions of matter. Polymer chemistry is many compositions of matter. Those type of things. And you have those 4, and then any new or useful improvement of the 4 can potentially be patentable. So a process, and those include computer programs and sometimes business processes based on electronics and other materials, machine-related processes, and then various products and compositions. So any improvement on those can also potentially. And a lot of what I see, I actually work as a contractor for the patent office, and I evaluate patent applications, and a lot of what I see are improvements over what's already been done. What is not patentable, just so that you know, are abstract ideas, laws of nature, or physical phenomena are not patentable. So this has to be something that you have actually come up with as a new innovation. And patents, the world of patents is a bit more complex than trademarks, which is basically, a trademark's a design or a logo or a tagline or something that you patent as your brand, that you trademark as your brand. But patents get a little bit more complex because there are a variety of different types of patents. And the 3 main types of patents in the United States are utility, design, and plant patents. And then there are also strategies that go along with what types of patents and patent applications to use in your strategy. For example, there are provisional patent applications, which are only good for 1 year as a placeholder, saying that I've come up with this idea. I'm not sure I want to invest in a non-provisional patent application, but I want to give a placeholder so no one else files their patent application before me, before I get that chance. So this provisional patent application never becomes a It's just as a placeholder, awaiting the time when you definitively decide, yes, I'm going to move ahead. And so sometimes it's used in that early, very early stage, as an early stage protection process, before you have maybe finished all of your business plan, et cetera, and decide, yes, I'm going to go ahead with this. It prevents you from having to spend a lot of money if you decide not to move ahead. The second type of only patent application is an international patent application. It's called a PCT, patent application. It never becomes a patent either, but it allows a 30-month period before you have to decide what countries you would want to get patent protection in. So it too is kind of a placeholder. The advantage of filing an international patent application such as this is there's also an international search report that's done. So you get additional information about whether your potential is good for actually getting patent protection. And in fact, that's the area I work in. I do those search reports. So that can be a useful tool in getting a placeholder, leaving yourself 30 months of development before then seeking patent protection in the United States or anywhere else in the world. The third form, in the United States, if you file a provisional, after 1 year, you either drop it completely or you would file a non-provisional patent application. And that's the typical patent application that goes through prosecution, back and forth with the patent office, and eventually could become a patent and give you protection of your product for a 20-year period from the filing date. And then the fourth is, in fact, the other option of national applications in other countries. You could file directly in other countries of the world. When you file a US patent application, that process could get very, very expensive. So it's really important to have assistance in developing a strategy for patent protection, whether it's in the United States or anywhere else in the world. So each country has its own patent system. And what you need to remember about intellectual property is that it's country specific. You have to protect a patent in the United States covers only the United States, but it does prevent anyone from making, using, offering for sale, or importing that product into the United States. So you already have a pretty good area of protection, a huge market that you've protected by protecting your product or your innovation in the United States.
Hey, Ellen, we have a patent-related question from the audience I want to read to you. This is from Alan. Alan says, patent application details used to be secured by the U.S. Patent Office until a patent was issued. Now, as soon as a patent application is filed, details are made public. How does this change benefit the inventor?
In fact, they don't immediately become public. You may see that they become public if someone filed a provisional. Just so you know, a provisional is never published. But if I file a provisional in 2016 and then I file a non-provisional in 2017 at the end of that 1 year period, it will publish 6 months later because every patent application worldwide, sorry about this, I don't know what's going on with my pop-up. Every patent application, oh no. Oh my word. Sorry about that. Every patent application, whether it's a PCT or any other country, they all publish in 18 months. And so you may get the impression that they publish immediately, but that's probably because a year later they filed a provisional, in which case the non-provisional will publish 6 months after filing. So it's not necessarily, the publication is an advantage for the people who are not the inventor because they are already put on notice that somebody else has filed on that innovation. And so they wouldn't waste their time and money filing something that's already in there. There is that 18-month period where you can't know. And so when I do patent research, you know, my research is based on that day, this is what's known, but a month later, something else may publish. which would indicate that maybe your new invention isn't patentable. We do our best to do research to be sure that when you file, you know pretty much that you can get one based on the research, but there is that 18-month period where it's unknown, that we can't know. On the other hand, the inventor, if you file a non-provisional in the United States, there is an option of requesting for a non-publication. And many times in defense-related technologies, there is a non-publication clause. And in fact, in secret defense things, you won't see the patent until it becomes declassified. And there may be patents on technology. So you can, if you don't want it to become public until it becomes a patent, you can make a request of non-publication. So
is there an additional cost for that?
Yes, I think that it's a minimum cost. All costs at the patent office for anything for a trademark, or you can look at USPTO fees, and there's a one page of everything that it will cost you for different things that you would request of either the trademark or patent office. So it's a fee that's not exorbitant, but it's a special request because the normal process is that it would publish. So remember, the goal of patents is to, in exchange for giving you a monopoly, a limited monopoly, in exchange for that, there is the fact that you disclose and you allow other people to benefit from what you have put in your patent application so that they can potentially use that to create other innovation. But once you file, that's the point where you're going to be protected and other people cannot then use that, or will not be able to sell products that are covered by your claims of your patent.
Thank you.
We'll go through, let's go through the process, and then maybe you'll understand a little bit better how this all works. And I have included here the US and international patent application processes. So I'm going to put these on a timeline. The PCT and the USA, the PCT, the International Patent Application, never becomes a patent until you file it in countries, because remember, patent protection is country specific. And then specifically the US system. So I like to start the whole process. You really should start looking at a strategy when you're in your R&D process prior to that 0-month point where you file your patent application. So once you filed that patent application, you then move into this period, as I said, from 0 to 18 months, it is unpublished. And anything from today back 18 months, I can't see, it's not publicly available. So there is, when you file your patent application, you've got 18 months, and I strongly encourage people, that 18 months is the period in which you're going to be doing as much of that whole pyramid, scale up, development, pitching. You're going to do everything you can to get that product out there before anybody knows about it. It is an advantage. So you really do want to move quickly. Once you filed, you want to do all of the rest of the work to get your product out and for sale as quickly as possible to benefit from the maximum of this. In the United States, after the 18-month, typically about that same time, it would enter into what we call the prosecution. And it's a big word to say, the patent office looks at your application and the examiner says, oh, that's not patentable. I did a search and for this reason, I don't think it's patentable. And then your attorney goes back to the patent office and says, yes, it is for this reason. And the patent office comes back and says, no, it's not for this reason. And they go back and forth 1, 2, 3 times. And eventually they decide whether it's patentable or not patentable. So it's the back and forth. And if you have done preliminary research in this very early phase, the chance of getting through this prosecution is about 98%. And it also, you'll get through the prosecution with very little back and forth, because in fact, your research will be very similar to the research that the patent office does. And if they don't find any other references that would show that your invention is not new and different, then they'll say, yes, you can get a patent. If you don't do upfront research prior to filing your patent application. If you wait for them to come back to you, it will be very, very difficult to get a patent. It could take a lot of redefinition. It would take a lot of back and forth. And this is where cost would become very important. So if you want to have a very efficient process, you need to have early upfront research prior to filing. So that's an important point. And the patent office is pushing also that there is upfront research so that it becomes a very efficient, cost-effective process without people just trying to flounder around, trying to see what they could potentially get for claims. So in that process, you see we arrive at that 30 months for the PCT at 30 months. And prior to this time, in fact, actually it's before the publication of a PCT, which is also at 18 months, the international search report is finished here. So when a PCT application publishes, you will actually see on the document that publishes the opinion of the International Search Authority. And it will tell you what the opinion is, whether it's going to be patentable or not. And so that, as I said, can be very useful because it gives you an indication of how useful and patentable it is. After the 30 months, or before the end of the 30-month period, you decide which countries, Germany, Great Britain, China, or including the United States, in what countries do I want to file to get that specific country-specific protection. And so then you end up with a granted patent in diverse countries. And it continues on through a period of up to 20 years. And during that time, in all countries, there's what we call annuity fees. You have to pay to maintain that patent throughout the life of the patent itself. If you decide not to for some reason, and I've seen it happen, the product just didn't turn out to work as well as expected, or it didn't sell. And you can decide not to pay those fees. And when you do patent research, you'll see that sometimes the patent document will say abandoned or expired or due to fees. Well, that's because the owner just decided that it wasn't worth their money to continue paying for something that they were not going to develop. And so annuity fees are paid in the United States. There are 3 different times that you pay a maintenance fee on them, and it's progressively more expensive because it's assumed that over the life of your product, you'll be making more money. So that's logical. In some countries of Europe, it's a steady fee, the same amount every year, and you decide every year if you're going to continue. In other countries, it has a progressively more expensive rate over a period of those years. So it just depends on each country. But at 20 years, it's the end of all patent protection. If it hasn't happened previous to that by decision of the owner, it will happen at 20 years. So in doing patent research, in fact, I've encouraged engineers at times, is a document that's more than 20 years old from its filing date. If you want to produce that product, you have absolute freedom to do so. It's like when books or music fall into public domain. They are now dedicated to the public, and you can literally follow the indications in the patent document and make that product with no fear of being not being able to, because it was protected. Now it's not, and therefore it's available for anybody to use. So that's how the process is. And I think you can see that patents, there could be very important decisions to be made throughout this entire process. And there are decisions to be made up to 20 years throughout the life of the patent. And that strategy that began with keeping information confidential and getting patent protection and then managing that technology over the lifetime, it's very important to have that strategy mapped out, at least to some extent, right from the beginning, if you want to benefit, if you want to have the greatest benefit from having patent protection.
So along those lines, Ellen, that maybe as a entrepreneur, if you're just starting out and you're trying to look ahead for 20 years, how I could see that would be like standing at the base of a mountain going, how do I know what my business is going to be like in 20 years. How do I know what I should be doing now? You know,
Yeah.
you know what I mean?
Yes. So what my experience with, I mean, I've worked in corporate intellectual property. It's a bit different, but there's still the same considerations. And one being, since you can't go back, what corporations do, which are very successful in maintaining patent portfolios, is number one, they do research. They're not going to file a patent application if they don't have a reasonably good assurance that they would get protection and that that protection would be useful to them and that they would get a return on investment. So research upfront is essential. The second thing is for entrepreneurs, I encourage them, if you're still having doubts, you're not sure where it's going to go, provisional patent protection is relatively inexpensive. It's something that gives you 1 year to continue developing as quickly as you can, but at the same time having that protection so that if you go and pitch your product, if you go and try and sell it to, you know, other players in that area, you're not going to have someone immediately steal it because they can't. You're not going to prevent yourself from being able to file a patent application later. So that's where, for entrepreneurs, where provisional patent applications can be extremely useful. It gives them the freedom to go out and move in trying to promote their product, at the same time giving themselves the option of patent protection at that 1 year period.
Makes sense. Thank you.
Yeah, and at the 1 year period, it becomes more evident of what needs to be done. The last thing I would really strongly encourage about provisional patent applications is do not take them lightly. They're not a temporary, easy patent application. They should be as seriously written as a non-provisional. If you want to get good protection of your product, you want to get lots of detail, and you want to have really thought through your, and as I worked as an intellectual property liaison for a Fortune 500 company in Latin America and Europe, and I often worked with engineers and PhDs on helping them think through the other options and think through all of the detail that they need to get into any document that they potentially would want to be able to use for patent protection. So it's an exercise that should be done prior to filing, even a provisional. Don't consider a provisional application a lesser application. Take it as seriously, because in fact, the process of filing a patent application, what you have to think through is an excellent exercise in refining and further defining your innovation, and sometimes coming up with even better innovation. Many, many times I had an engineer come to me and say, oh, I have this idea. And then as we began to talk about it and think through what kind of protection and doing the research and talking and discussing it, they came up with 2 or 3 more ideas that were even better. So it's an exercise I encourage everyone to go through.
Hey, Ellen, I have a couple questions here for you. Do you want to entertain those questions now about patents in particular? Okay.
Sure, that would be fine.
First one is from Richard. He says, is the 18 months for a provisional first? I'm not sure.
18 months. The 18 months is, like I said, if you file a provisional, it will never publish, but you have to file a non-provisional after it. So you have to remember, a provisional is only 12 months long, and if you have to file a non-provisional after, within that 1 year period. And at 18 months, if you claim priority to the provisional, the non-provisional will publish, in fact, 6 months later, because it claimed priority all the way back to here. So if I had
started way back there.
Then if you want the clock, and it gets a little complicated because it's what we call prior art, this becomes the date which anyone inventing it before then, I can use that against them and can be used against them. But if somebody came up with the same idea here, it can't be used against them because this is your date. So, oops, sorry.
Yeah, no, got it. Another question from Joe is, how can the physical prototype of a patent be insured for its replacement value?
A prototype of a patent.
It says, how can the physical prototype of a patent be insured for its replacement value? So I guess what he's saying is if you make something in the aerospace world, for instance, you create a new, I don't know, a new airframe.
Right. Oh, for its value, that would be a tough one. I think you'd have to talk with an insurer because, okay, if you're in the aerospace work and you create a new plane, you'd have to talk with people who insure planes, and because it's a prototype, I assume that the valuation of that prototype would be based on the nearest possible related type of plane.
Right.
And obviously it has more value if the value, because there's innovation value there, but I suppose you would go talk with an insurer and get them the closest possible, and then maybe increase that by what you estimate the innovation is worth that's included in that new prototype.
Got it. Thank you.
Mm-hmm. Any other questions?
Okay. There was one other. It was regarding a trademark. Should you register your trademark?
Oh, that was a good question. I'm glad that we brought that up. In fact, if you're early in the process, when you create your logo or your name of your company, you can always put TM after it. It's common law use, and you're just notifying people that's your trademark. You don't have to register it. But it's important to do the research. We do patent research to determine whether you can get a patent. Trademarks are the same. You should do, like I said, namecheck.com. You can find out whether you potentially could get that as a trademark. You don't need to register it immediately, but you can begin using TM after it. The circle R is when it is registered. So you cannot use the circle R unless you actually get registry from the U.S. Patent and Trademark Office. But you certainly should do the research to make sure that you're not using someone else's design or trademark. And
got it.
Okay.
The bottom line is research, research, research.
It is. I was subject today, so I'm just going to go through. These are just the key points which I've already brought to your attention. Intellectual property is country specific. Decide on the type of protection based on your product. What is protected? Patents. It's the functional expression. Design patents. You can get a design patent, but it's just the physical appearance. Copyright protects creative expression in all its forms, and trademarks or service marks identify the source of origin, and they're the most intimately related to your brand. So those are important to build your brand as you're building your product. You would really want to consider getting a domain name, a trademark. And like I said, a trademark could just be putting a TM, do the research, and then later, once you've really assured that that's the trademark you want, you could register it. And then you could also decide on other forms that are suitable, as we talked about, copyright, patent, trade secret, or sometimes even defensive publication, but we won't get into that today. But most innovation is concerned by combinations of all of those. So seek help from a professional, especially you do need a trademark attorney to get a registered trademark if you don't just want to use the TM and consider it common law use of the mark. You do need a patent attorney to get a patent. So get professional help, but do your research up front. It will speed up the process immensely. And this is the last thing, advantages and benefits. When you own intellectual property, you have added value, you have a reputation of innovation, you have that limited monopoly, especially with patents. You're building brand equity, you have a leverage in negotiation for raising money, for creating collaboration. When you have intellectual property, you have an advantage. And then there are also licensing opportunities. When you don't own it and you're not sure what others have, you run a risk of infringement. You could end up in litigation, which is extremely expensive. You will lose all the work you've accomplished up to that point because you'll have to start over, whether it's with your trademark or your product. and you will have limited freedom, and you will have to license. You will have to pay someone else money, and maybe that wasn't worked into your business plan. So it's important to know where you can go, what are the obstacles and what are the opportunities. And an IP strategy is really used to promote innovation and to mitigate risk. So that's all I had. And if there were any other questions.
Well, I have a question for you, and it is, you know, again, as innovators and entrepreneurs, people are, you know, often probably, again, feeling like they're standing at the base of a mountain with something like this, and it can be a little overwhelming. And you've given us some fantastic information here. How, in one of your last slides, you said seek professional help. How do you recommend doing that? I mean, because as an entrepreneur, I may not have any cash. I probably don't have any cash flow. So how do I look at doing something expensive like going to an attorney? Should I go to an attorney right away? Do I come to a FRESCO Services right first to do the research and then go to a patent attorney? And I guess how would you recommend people get that professional help?
Well, I think there are organizations like my own that do patent research. If you were in considering a strategy, I would talk with, if you need to get your research done, which most people would, I would recommend getting the research done and then going to a patent attorney, because you're in such a better place to sit down and discuss with the patent attorney what you believe to be the new and different features of your product. If you don't do research up front, when you go to a patent attorney, they'll say, what's your thing? Do you want me to file it? And you'll say, well, this is it. And you'll ask them, can you file this for me? And they'll say, yes. But then you may not have it may become a long process because the upfront research isn't as strong. So talking with a patent attorney is good. Getting research done is good. The Patent and Trademark Office, I can just assure you, they have a service for entrepreneurs. You can contact the Patent and Trademark Office and get help from them also. I wouldn't recommend people use online, like there are sources online that say, we can help you file a provisional patent application and you're good. You're never going to get what you pay for, and you're not going to get a good provisional. Like I said, a good provisional requires a lot of research and discussion to define the invention, and you can't just do that by clicking on and filling out a few things on an internet site. You will get something filed, but it won't be sufficient. Attorneys go crazy when people, you know, do that themselves and they file a provisional and there isn't nearly enough information in there to file a real patent application. So, you know, myself or other research organizations, I love patent research because you can get so much information. And if you need, I can refer you people, if they want to contact me, I can refer perhaps people closer to where they live that can help them with that. So don't hesitate to contact me, and I can try and direct them to appropriate sources, perhaps closer to where they are.
Could you put your contact information back up there, please?
Sure.
We had it on that last. There we go. Thank you. Thank you very much. So I think for me, a bottom line takeaway is, like anything in life, usually you get what you pay for. And so if you are spending the time and the sweat equity and, you know, the hours to build a business and you have a great idea, to me, it just seems worth it to, you know, to do the research and then go to the patent attorney. So you're not spinning your wheels with a patent attorney, and you're not spending more dollars than you needed. Get the research done first and then go to the patent attorney. And it sounds like by doing that formula, you have your bases covered and, you know, kind of know where you stand. Does that sound about right?
Absolutely. Yeah.
Great.
And the patent attorneys I work with are very happy to have that research done up front because it makes their life easier too.
Yeah. And for the entrepreneur, it's money much better spent. You're not they're not spinning your wheels with a patent attorney and, on an hourly basis. They can go in there and, with the research done and feel like, their time with the attorney is productive and efficient time.
Right.
Well,
right.
Great. And I have another question that came up earlier, actually about Aero Innovate, and it was regarding the pitch and mingle, about how people can get invited to the pitch and mingle event, which again is on July 25th in Oshkosh during AirVenture. And what I would suggest for that is we will be sending out emails and invitations, getting closer to the event. So I would highly recommend going to checking out aero-innovate.org or any of our social sites, or feel free to send me an email directly if you'd like to get put onto our mailing list so you don't miss anything. That is Slocum, S-L-O-C-U-M-S @uwosh.edu, uwosh.edu, and I will be happy to put you in our database, and you get all of our mailings that we send. And I say all. We're not going to inundate you with emails, but it is a great way to stay up on things, and of course our social sites as well. So thank you for that question. I think we are good. No more other questions are coming through, and we are at about 40 minutes here in time. So if there's no more questions, I will just kind of wrap up by saying thank you once again to Ellen Krabbe and FRESCO Services. Ellen, it's been you've provided us with a ton of valuable information, and folks can again access that information on aero-innovate.org. We should have this webinar posted by the end of this week at the latest. And again, Ellen, you're more than welcome to post it to your site as well, so then people can go to FRESCO Services website as well. So anything else? Any parting comments, Ellen?
Well, I'm excited to be in contact with you all, and I look forward to innovation. Aero innovation's been so great over the last century, and I anticipate that things will continue to be very exciting as we're moving into new innovation. So thanks for letting me involved with what you're doing.
Absolutely. I'm glad we were able to make the connection. And folks listening out there, again, another plug for Aero Innovate. One of the things that we do, we talked about our mission to help aero innovators bring their product to market. And during our accelerator process, we connect all 5 of our cohort companies with various mentors along the way that belong to our advisory board, and then mentors sort of on an ad hoc basis. And we've made this great connection with Ellen, and it's a great example of mentor resources that we have, or someone coming into our program that may need help with intellectual property. We have the ability to get you connected with a fantastic mentor like Ellen and help you along your way. So thank you. And thanks to everyone out there for participating. Again, check it out, posted on aero-innovate.org. Check out FRESCO Services as well. Ellen Krabbe. Ellen, thank you very much. And everyone out there, have a fantastic rest of your week, and be safe.
Thank you.
Thank you. Bye-bye.